without reasonable consideration for other persons using the highway, and on conviction is liable to a fine of not less than $400 and not more than $2,000, or to imprisonment for a term of not more than 6 months, or to both. And in addition, his or her license or permit may be suspended for a period of not more than 2 years. Due to Ms. Stalker slowing and accelerating, my client had difficulty adjusting her speed because she was fully loaded. Ms. Ryder's testimony and cross-examination never wavered. Ms. Stalker, on the other hand, testified she was driving a spare bus she has only driven a couple of times.
It does not involve proof to an absolute certainty. It is not proof beyond any doubt, and nor is it an imaginary or frivolous doubt. When the evidence is applied logically, one can see clearly that it is not the actions of the bus driver that this court must assess. It is whether or not Ms. Ryder acted.
No. What we want to do now is have a little fun with this. So who do you think was more convincing as far as our prosecutor or the defense counsel here?
The defense was definitely more, they were on the ball a little more. I gotta say, Jody, A, you brought back lots of memories. B, you captured the absolutely snotty attitude of the municipal prosecutors.
Before we began, I said, I really gotta dig deep and hone into my, internal bitch. And Felicia goes, no, just act yourself.
No, but you captured. That's the way.
Yeah, let me clarify that for you. So the voir dire is a trial within a trial, and the purpose of the voir dire, as His Worship outlined, is to determine one issue: whether or not the statement that Ms. Ryder gave was voluntary. Because if, in this instance, the court ruled it wasn't voluntary, so in that instance, that was the end. That little hearing that we had within the context of the big trial was to determine that one isolated issue. And so when the defense counsel was referring to bail, what she was actually doing was referring to a piece of case law and
All right.
Well, go ahead, yes, sir.
You did say it.
All right.
Thank you. Prepared to deliver my decision.
I'm having some trouble with the microphone here, so if anybody has difficulty hearing me at any point, say so. I'll try to speak up. Ms. Tina Ryder was arraigned on a charge of careless driving, contrary to Section 130 of the Highway Traffic Act. A plea of not guilty was entered. Ms. Burness for the prosecution called 2 witnesses. The first witness to testify was Officer Dooley of the Huronia, Ontario Provincial Police. This officer testified that he was on duty on the morning of June 21st, 2011, when at approximately 6 o'clock a.m. he was dispatched to the scene of an accident some 2 kilometers away. He arrived on scene at approximately 6:30 a.m. after a delay necessitated by essential police business. Upon arrival, he noticed 2 vehicles, a school bus and what he referred to as an 18-wheeler. He observed significant damage to the rear of the bus and front of the truck. Officer Dooley ascertained the identity of the 2 drivers and obtained statements from each. The statement of the defendant was ruled inadmissible following a voir dire. Upon cross-examination by the defense, Officer Dooley testified he was a relatively inexperienced officer, having been an officer for only a few months. He also conceded he had few notes involving the actual investigation he conducted. The second witness for the prosecution was Janet Stalker, the driver of the school bus. Ms. Stalker testified she was the driver of the bus on June 21st, 2011. After turning left onto Highway 26 and gaining speed to 80 kilometers per hour, Ms. Stalker saw a transport, quote, on my bumper. Ms. Stalker testified she activated her brakes to signal the following driver to back off, which they did for a few seconds. As she approached a bend to pick up her first student of the day, she activated her flashing lights. Not seeing a student waiting as expected, Ms. Stalker deactivated the lights, only to immediately see the student running. She once again activated her 4-way flashing lights. Ms. Stalker testified she saw the truck in her mirrors and thought it was just too close before being struck. Upon cross-examination by Ms. McGrath, Ms. Stalker testified she was trained as a bus driver and considered herself to be a safe driver. She was driving a, quote, spare school bus. She also testified the left mirror was loose, a defect she was aware of before driving that day. She admitted she braked to give the truck driver a warning rather than pull over, and she testified she drove with the overhead lights on for a couple hundred meters without stopping, again to give a warning to the truck driver. At the close of the prosecution case, the defense made a motion for non-suit, arguing this court had not heard some evidence of all the essential elements of the charge. I denied this motion for the reasons given at the time. The defense elected to call the defendant, Tina Ryder, to give evidence. Ms. Ryder testified she's been a truck driver for many years. She also testified she was driving on Highway 26 with a load of drywall on June 21, 2011. She saw the school bus make a left turn and enter onto the highway in front of her. She said she was concerned the driver of the bus had cut her off and that she was concerned about being able to stop. It was her testimony that the driver of the bus sped up and slowed down and activated her brakes a couple of times, as well as the overhead lights. Ms. Ryder testified the bus came to a dead stop without warning, resulting in a collision. The entire sequence of events was estimated to have lasted about 1 minute. Through Ms. Ryder, the defense entered a number of photographs depicting the accident location. Under cross-examination, Ms. Burness questioned Ms. Ryder about the distance between the vehicles and the expected behavior of school bus drivers. Ms. Ryder did not accept the prosecution's suggestions. The defense called no further evidence. The charge of careless driving reads, every person is guilty of the offense of driving carelessly who drives a vehicle or a streetcar on a highway without due care and attention or without reasonable consideration for other users using the highway. I am satisfied that the essential elements of date, place, and time have all been established. I am also satisfied that the identity of the driver of the truck has been established as Tina Ryder, the defendant before me today. The manner of driving must be such a departure from the standard that it is deserving of punishment. I, of course, take this direction from His Honor Justice McKay in Regina v. Beauchamp. The evidence of what transpired on June 21, 2011 came from the drivers of the two vehicles and from Officer Dooley. As the officer was not present at the time of the accident and performed little by way of investigation at the scene, this court is left with the two competing versions of events as told by the civilian witness, Janet Stalker, and the defendant, Tina Ryder. As it is Ms. Ryder who stands charged, it is her manner of driving on June 21st that I must weigh against the reasonableness standard. I am persuaded by the case of Regina v. Skowronek, a Saskatchewan District Court decision which found that, quote, it is, however, an objective standard of care and attention, not related to the degree of proficiency or experience of the particular accused that it involved. It is wrong to assume that there is one standard for ordinary drivers and another for others. Therefore, just because Ms. Ryder is a truck driver, which can be inferred to require a greater degree of skill and ability than your average ordinary everyday car driver, Skowronek tells me it is wrong to require more from a professional driver. The standard of care is the same for all drivers on the road. In evaluating the evidence given by these witnesses and coming to a decision, I am directed by the Supreme Court of Canada decision of Regina v. WD. I must also have regard for the evidence and the standard of proof in view of the Supreme Court's decision in Lithquist. To paraphrase, if I believe that the defendant is probably guilty, it is not enough to tip the scale in favor of finding of guilt. In consideration of these two guiding principles and in weighing the testimony of the defendant, which I believe to be true, I hereby dismiss the charge of careless driving.